Picture this. A courtroom in Delhi, absolutely packed. The date is April 16th, 2025. Right there, in the center of it all, is the Chief Justice of India. The tension in the room is, well, you can feel it.
Yeah, palpable.
Because the case being heard isn't some minor squabble. It strikes right at the heart of faith, at ownership of property, and at India's fundamental idea of religious freedom.
Absolutely. And the subject causing all this.
The Waqf Amendment Act, which came into being just this year, 2025.
Right.
This isn't just about old documents gathering dust. It's a real legal drama unfolding with potentially huge consequences for a significant community and the whole balance of power in the country.
It really does grab your attention, doesn't it? Now, before we get too deep into legal wrangling, it's probably helpful to understand just what a waqf is.
Good idea.
Think of it as a permanent charitable endowment under Islamic law. This could be anything, land, buildings, maybe even money that's been dedicated to religious or public benefit. So you're talking about things like funding the upkeep of a mosque, supporting a school, or providing aid to people in need. That's the sort of core idea.
Right, a permanent commitment.
Exactly. And the crucial thing to remember is that once a property becomes a waqf, it's essentially locked in for good. It can't just be sold off or, have its purpose changed later on.
Permanent. Got it. It carried this weight of history, representing centuries of tradition and community support. Now, fast forward to April 2025, and this Waqf Amendment Act is passed. On the face of it, you might think, okay, this is just about bringing the management of these waqfs into the 21st century, updating things.
Seems reasonable, right?
But what's happened is it's ignited a major legal firestorm. I mean, we're talking about a staggering 72 petitions landing on the Supreme Court's doorstep.
72. That's not just a few disgruntled voices.
Not at all.
Not at all. And what's particularly interesting is just how diverse the group of people and organizations filing these petitions is. It's quite a mix.
Yeah. Like who what?
Well, you've got political figures like Asaduddin Owaisi, major religious bodies such as the All India Muslim Personal Law Board, the AIMPLB, which is a big deal in Muslim personal law.
Right, very significant.
And Jamiat Ulama-e Hind, another prominent Islamic organization. But then you also have political parties like the DMK from Tamil Nadu and even individual members of parliament from Congress joining in.
Wow. So it's a really broad coalition of voices, all expressing pretty serious concerns about this new law.
Definitely. A wide range of opposition.
Absolutely. So our aim with this deep dive, for you who are listening, is to really unpack this complex legal situation. We want to get to the heart of the arguments, both for and against this act.
What's really at stake?
Exactly. What are the fundamental constitutional questions being raised? And ultimately, why does this unfolding drama in the Supreme Court matter for understanding the bigger picture of law, religion, and, how society functions in India today?
Okay, so where did the court start? April 16th, the three-judge bench, Chief Justice Khanna.
Right. They didn't immediately jump into all the nitty-gritty legal arguments. They started by asking two really fundamental questions, didn't they?
They did. The very first question the Chief Justice raised was about jurisdiction. Basically, should the Supreme Court be directly hearing all these 72 petitions right now? Or, should they perhaps be directed to the various high courts across the country first? It's a critical procedural point, really.
Makes sense. The Supreme Court must have a massive workload.
Oh, absolutely. And they often prefer for these kinds of matters, especially ones with, let's say, local angles, to be handled at the high court level first.
Okay, that makes perfect sense from an administrative standpoint.
Right.
And the second key question they posed was much more direct.
Yeah.
Right? Yeah.
What are the main complaints? What are the petitioners actually arguing against, in a nutshell?
Right. With so many petitions flying in, the court needed a clear, concise overview of the core objections. They didn't want to get lost in the weeds right away.
Exactly. They needed the main thrust of the challenge. And the petitioners, it seems, came well prepared with their key arguments.
Okay.
They're essentially contending that this act is deeply flawed from a constitutional perspective. They're arguing it infringes upon several fundamental articles of the Indian Constitution.
Which articles are we talking about?
We're talking Article 14, which guarantees equality before the law.
Okay.
Article 15, prohibiting discrimination based on religion, race, caste, etc.
Right.
Article 25, freedom of conscience, practicing religion. Article 26, which gives religious denominations the right to manage their own religious affairs. And finally, Article 300A, which is about property rights, no one deprived of property except by law.
Those are some pretty foundational rights that they're arguing are being stepped on. Let's get into some of their specific objections. One that keeps coming up is this 5-year Muslim rule.
Hmm.
What exactly is that about?
Yeah, this is a real sticking point. The new act specifies that only someone who has been practicing Islam for a minimum of 5 years can actually create a waqf.
Practicing Islam for 5 years. How? How do they even determine that?
Well, that's precisely the point Kapil Sibal, representing some petitioners, raised. He basically asked, how can the government dictate this? How can the state decide whether and how someone is a Muslim or not, especially for making an endowment? It immediately throws up this fundamental question about the government's authority to, define or assess someone's religious practice. It feels almost like a religious test imposed by the state.
It does sound incredibly invasive, doesn't it? The state deciding who's Muslim enough to make a religious donation seems, well, counter to religious freedom principles.
Absolutely, and potentially discriminatory.
Right. Another major bone of contention is the removal of something called Waqf by user. This sounds like an old practice. What is it?
Waqf by user is, it's a long-established principle in Islamic law. Essentially, it recognizes that if a property has been used continuously by the community for religious purposes for a long time.
Like a mosque or a graveyard.
Exactly. Think of a mosque or graveyard used for generations. It becomes recognized as a waqf even without a formal written deed. It's based on sort of long-standing community use and religious purpose.
Okay, established practice.
But the new act insists on written deeds for all waqfs. It effectively scraps this whole waqf by user concept.
Oh.
And as Huzefa Ahmadi, another lawyer for the petitioners, argued, waqf by user is an established Islamic practice and cannot be taken away. The big worry is that tons of historical religious sites, especially in older areas, might not have formal paperwork going back centuries.
Right. How do you suddenly produce a deed for a mosque that's been there for hundreds of years but maybe never got formally registered?
Exactly. That's a really practical and significant problem. The Chief Justice himself seemed to pick up on this.
Did he?
Yeah, he noted that while maybe the principle was misused sometimes, just getting rid of it completely could create a huge headache for legally recognizing and protecting these older sites without formal papers.
Yeah, it feels like throwing the baby out with the bathwater, maybe. Discarding a tradition because of potential isolated issues.
Precisely. And then we have the rather interesting issue of including non-Muslims on Waqf boards and the Central Waqf Council. That's also drawn a lot of fire.
Okay, what's the argument against that?
The argument boils down to the core idea of religious autonomy. Petitioners say mandating non-Muslims in the management of Waqf boards is an unwarranted intrusion into their religious affairs.
Intrusion.
They draw parallels saying, look, Hindu temples, Sikh gurdwaras, their management bodies are typically made up of members of their own faith. One Congress MP's petition called it unwarranted interference in religious governance.
And didn't this lead to a pretty sharp question from the Supreme Court itself?
It did, a very direct one. The bench asked the center, basically, okay, are you willing to allow Muslims to be part of Hindu religious trusts?
Ooh, that cuts right to it.
It really does. It raises that fundamental issue of reciprocity. Is the government applying the same standard everywhere? It challenges them on whether they'd be okay with similar involvement in other religious institutions' management. The implications for religious autonomy are pretty profound.
It really makes you think about equal treatment, doesn't it?
Okay.
Okay, so it wasn't just about who sits on the boards. There's also this concern about shifting power to government officials for deciding what even is a WAF, right?
Yes, another major point. The Act empowers government officials, like district collectors, to decide if a property is a WAC when there's a dispute.
A district collector.
Yeah, and Kapil Sibal strongly objected, saying effectively the collector is part of the government. If there's a dispute, this official is basically a judge in their own cause, which he argued is per se unconstitutional on its face.
Because of potential bias.
Potential bias, blurring the lines between government and religious bodies. Petitioners worry it undermines the independence of Waqf boards and could lead to, politically driven decisions. It raises big questions about the separation of powers.
It certainly sounds like it could create a situation where the government has undue influence over religious properties. And then sort of underlying all these specific points is the broader argument that the act unfairly discriminates against Muslims specifically.
Absolutely. Petitioners like Asaduddin Owaisi have used really strong language, hostile discrimination. a brazen violation of Muslim rights.
Strong words.
The core argument is that this act puts specific restrictions and regulations on Muslim endowment that just aren't applied to similar trusts or endowments of other religious communities in India. They say this differential treatment violates the constitutional guarantee of equality.
Okay, so those are some really powerful arguments against the act. What's the government side of the story? How are they defending this legislation?
Well, the government, through the Solicitor General, has put forward a defense on several fronts. A key part is stressing that the act wasn't rushed. It came after, supposedly, an extensive consultation process.
Consultation.
They highlighted a joint parliamentary committee, 38 meetings, examined nearly 100 witnesses, reviewed over 2 lakh memorandums. They're emphasizing this thorough vetting process.
Trying to show due diligence.
Exactly. And they also point to the parliamentary votes it passed in both the Lok Sabha and Rajya Sabha and got the president's approval. They're underscoring its democratic legitimacy.
Okay, that covers the process. What about the substance? What problems are they claiming the act fixes?
Their main line is that the act is about reform, bringing greater transparency and efficiency to how Waqf properties are managed.
Reform and transparency.
They argue there have been long-standing issues: incomplete property surveys, mismanagement of funds, patchy record-keeping by Waqf boards. Union Minister Kiran Rijiju talked about inclusive growth, suggesting these reforms are meant to benefit the Muslim community by making sure Waqf properties are properly identified, protected, and used correctly.
So, tackling mismanagement and potential corruption.
That's the claim: better administration.
And what about those specific contentious points, like getting rid of Waqf by user? How do they justify that?
On Waqf by user, the government position is that this practice, well, it's been misused, led to land disputes where people claimed properties as Waqfs without proper proof or documents.
Okay.
They argue that insisting on written deeds brings clarity, legal certainty, and reduces these kinds of challenges. But, as we mentioned, when the Chief Justice specifically asked how existing undocumented Waqf by user sites would now be registered and protected, the government didn't seem to have a clear answer ready. That suggests it's still a bit of a weak spot in their argument.
That lack of a clear answer does seem telling. What about their reasoning for including non-Muslims on the Waqf boards?
The government argues that including non-Muslims brings, diverse perspectives and boosts accountability in managing these endowments, a way to ensure better oversight, prevent mismanagement.
Accountability through diversity.
That's the rationale presented. However, it seemed less solid when the Supreme Court pushed back with that question about reciprocity about Muslims on Hindu trusts. The Solicitor General seemed hesitant to give a direct response there.
Right, that hesitation again. It makes you question if the principle is being applied consistently.
It does.
It's interesting, too, that even before the hearing, the government took a proactive step.
Yes, that's right. On April 8th, the center filed a caveat in the Supreme Court.
A caveat, what's that?
It's basically a legal notice saying, hey, court, don't pass any orders on this Waqf Act issue without hearing our side first. Given all the petitions coming in, it was a strategic move to ensure they wouldn't be caught off guard.
Makes sense. Get their argument in from the start. So where does the Supreme Court currently stand in all of this? They've heard these initial points, but no final rulings or even a stay on the act yet.
Correct. As of that initial hearing, the act is still in effect. No stay order. But the bench, led by Chief Justice Khanna, was clearly very engaged, asking probing questions to both sides. It shows they're taking this very seriously.
Okay. And what were some of the key concerns or notable things the court itself said or asked during that first hearing?
Well, one definite area of concern for the Chief Justice seemed to be the whole Waqf by user issue and its abolition. He kept coming back to the practicalities. How do you register and protect these historical properties now without the old documents?
Right, the practical impact.
That suggests the court sees the potential real-world problems. And then that question about Muslim involvement in Hindu trust, that was a really significant moment.
Definitely stood out.
It directly challenged the government's reasoning for non-Muslim inclusion on Waqf boards and highlighted that whole principle of equal treatment and religious autonomy. Also, Abhishek Manu Singhvi, for some petitioners, made a strong plea for the Supreme Court to keep the case itself, arguing it's of national importance, rather than sending bits off to different high courts. That signals how high the petitioners view the stakes.
It definitely feels like the Supreme Court gets the weight of this. It's clearly more than just property law. It's hitting fundamental rights, the state-religion relationship.
Absolutely.
We've talked about the main petitioners and the government. Who else is involved? Any other key players with a stake?
Yeah, it's not just those two sides. Several states governed by the BJP, Haryana, Maharashtra, Madhya Pradesh, Rajasthan, others, have actively joined the case to defend the act's constitutionality.
So state governments backing the central government's law.
Right, showing political support within the ruling party's sphere. But then on the other side, you also have interventions from some Hindu organizations like the Akhil Bharat Hindu Mahasabha and Hindu Sena.
And what's their position?
They're actually supporting the new act. They argue it fixes problems they saw in the previous 1995 law.
Interesting. So support for the act coming from different quarters, too.
Exactly. It really underlines how complex and politically charged this whole thing is, with diverse, often conflicting viewpoints involved.
It really paints a picture of a deeply complex situation. So stepping back from the courtroom for a second, what are the broader implications here for Indian society as a whole?
Oh, the implications are pretty significant. Firstly, it really throws a spotlight on that ongoing tension, the delicate balance between religious autonomy and how much the state should control or oversee religious affairs. The outcome here could set a major precedent.
A precedent for the future state-religion relationship.
Definitely. Secondly, it brings up crucial questions about equality under the law. If the act is seen as putting unique restrictions on Muslim endowments compared to others, what does that mean for the constitutional promise of equal treatment?
A big question.
Thirdly, there's the historical significance of Waqf properties. This law, especially the bit about Waqf by user, could really impact that heritage, potentially erasing the legal status of some historical sites.
That potential loss of heritage.
And finally, let's be frank, you can't ignore the politics. With ongoing elections and the broader discourse around religious minorities, the political dimensions are undeniable. How this case plays out will have political ripples.
It's so clear, yet this is far more than just some dry legal argument. It touches bedrock principles of the Constitution, that crucial balance between the state and diverse religious communities. The Supreme Court is clearly engaged. But as you've laid out, so many questions remain unanswered. The practicalities around Waqf by user seem like a huge issue. And the government's, let's say, hesitation on that reciprocity question regarding religious trusts, well, it speaks volumes.
Absolutely, and it leaves us and everyone listening with a really crucial question to ponder, doesn't it? Given the long history and the undeniable social importance of religious endowments in India,
Right.
and thinking about those constitutional guarantees of religious freedom and equality, how should a modern state navigate this? How do you balance oversight and autonomy for these institutions?
That's the core dilemma.
What principles should guide laws like this? How do you ensure accountability? Yes, but also robustly protect religious rights for all communities without creating this perception, fair or unfair, of targeting one particular group? It's a question that really gets to the heart of India's secular framework and its commitment to justice and equality for everyone.
A profound question to leave our listeners with. Definitely something requiring deep thought long after this deep dive ends.